Hi, and welcome back to Mr. Raymond's Social Studies Academy for my AP Government series, where today we are going to finish Unit 3 with a closer look at the Due Process Clause, judicially interpreted rights to privacy, social movements, equal protection, and governmental responses to those movements. We're going to take a closer look at one of our foundational documents, Dr. Martin Luther King Jr.'s letter from a Birmingham jail, as well as the SCOTUS case Roe v. Wade, in some more detail. And it's kind of ironic that we are picking up back here because me and a lot of other AP government teachers just spent about 2 weeks grading an essay on this very topic. I guess it was meant to be. Anyway. Can we start by giving a shout out to the 14th Amendment once again? Oh, how my students get sick of me talking about it. Okay, so we talked about it last time, the 14th Amendment with selective incorporation, or how the 14th made most of the Bill of Rights protections apply to state governments. And we're going to be looking again a little closer at the Equal Protection Clause, but today let's start out by examining the Due Process Clause. A lot of what we're going to look at today is review, but let's take it up a notch. Be sure to pay attention to governmental responses to these key issues and the key constitutional provisions, both of which are types of evidence you're going to need for your AP FRQs, as well as your multiple choice section. So let's start with due process. And if you look up a definition, you might get something like a constitutional requirement that the government must respect legal rights owed to a person. Another way to define due process is that it prohibits, quote-unquote, arbitrary deprivation of life, liberty, or property by the government, except as authorized by law. In other words, the government better have a good reason and the law to back them up when denying, quote-unquote, life, liberty, or property. Okay, so life, liberty, and property. We've talked about these before when we learned about how Thomas Jefferson kind of borrowed this phrase with a slight change at the end when he was writing the Declaration of Independence. But a word like liberty can mean a lot of different things to a lot of different people. For now, we're going to focus on two aspects of due process, and we'll start with what is referred to as procedural due process. Often we think about criminal proceedings or rights of the accused when we hear due process. Most likely because the plaintiff in these cases is the government, and many of the protections from the Bill of Rights are due process rights. Due process can also be found in the Fifth Amendment of the Bill of Rights, but that only applied to protections from the federal government. The 14th Amendment made due process rights apply to state governments. And let's face it, most Americans' interactions are usually with state and local governments, including civil and criminal courts. The case of Gideon versus Warinright that we discussed last time is a perfect example of procedural criminal due process case. We know it as the case that provides us with an attorney if we cannot afford one, but Gideon was able to argue that denial of counsel, aka the Sixth Amendment, by the state of Florida in his case was a violation of his 14th Amendment due process rights. And again, the plaintiff in this case was the government, in this case, the state government of Florida. However, due process is not simply about the rights of the accused. What is called substantive due process allows courts to protect certain fundamental rights even if they aren't in the Constitution. Now, substantive due process leads us to our next benchmark, Roe v. Wade. This case and precedent protecting abortions has been in the news a lot recently as it's being challenged by certain state laws. And we are expecting the Supreme Court to release an opinion on these laws and potentially this precedent. In the opinion of Roe v. Wade, the court ruled that a Texas law, not the current one, but the one back in 1973, a Texas law that outlawed abortion was a quote-unquote violation of the Due Process Clause of the 14th Amendment. The opinion goes on to say that the rights of personal privacy includes the abortion decision. We mentioned before how the right to privacy is not in the Constitution. And while some interpret the right as implied in other amendments and cases, It is Roe versus Wade that sets the legal precedent that the right to privacy is part of our due process rights. Now, while many social campaigns revolving around the issue of abortion between so-called pro-choice and pro-life activists continue to play out, I think it's fair to say that members of both sides of the issue would still like to see the right to privacy in our due process continue. Now, on to our next benchmark. We're going to crank through the rest of these. We're going to look closer at social movements and equal protection. And you'll be expected to be able to, quote unquote, explain how constitutional provisions have supported and motivated social movements. All right, anyway, are you immediately thinking about the First and 14th Amendments? Me too. So we've seen a surge in social movements throughout modern history, including recently with environmental activists, women's rights, the Black Lives Matter movement, and social movements like women's suffrage, civil rights movement, LGBTQ rights are examples of ongoing debates about what policies and laws have violated equal protection laws and need to be addressed by the government. Remember, it all comes back to this clause. Look at this woman out here. Wouldn't your AP government teacher be proud if that was you? So we breezed through Dr. Martin Luther King's letter from a Birmingham jail in our last lesson, one that exemplifies civil rights, due process, and especially equal protection of the laws. Honestly, there is so much in this document that when College Board added it a few years ago, a list of 9 foundational documents that AP government students would need to be able to use in an argumentative essay, I wasn't sure what aspects they wanted us to focus. We know Dr. King had fought hard against discriminatory state laws that were in clear violation of the 14th Amendment's Equal Protection Clause. So that is what you want to associate most with this document. But certainly there are other constitutional aspects addressed in this document. In my class, we read excerpts of this exceptional document, which is remarkably long considering that it was written by hand on scraps of paper in a jail cell. There are some great quotes. Injustice anywhere is a threat to justice everywhere. And to his fellow bishops who he had addressed this letter to, who urged him to wait, that his sit-ins and boycotts and protests were just making the movement look bad, he responded, quote, "Justice too long delayed is justice denied." Also, Dr. King emphasized non-violent civil disobedience, which is another takeaway from this must-read document. Dr. King's patience paid off because 1 year after he wrote this document, the Civil Rights Act of 1964 was passed, prohibiting legal discrimination based on race, color, sex, or national origin, followed a year later by the Voting Rights Act, which outlawed the last vestiges of discriminatory state voting laws. This is another issue that's been back in the news. Finally, we're going to finish up this lesson by quickly looking at an overview of governmental responses to social movements and equal protection. And historically, the government has had a mixed response. The SCOTUS case of Plessy versus Ferguson in 1896, which you probably learned about in APUSH and some other course, established the legal precedent nicknamed separate but equal, which basically legalized segregation and paved the way for states to pass segregationist legislation, often referred to as Jim Crow laws. And this was around 30 years after the 14th Amendment's Equal Protection Clause was passed. It was just being ignored. Well, thanks to the hard work of many social movements, interest groups, and the activists, the government did finally respond. In 1954, with little help from the NAACP, which we'll cover later, SCOTUS handed down its opinion in Brown versus Board of Education, overturning Plessy and establishing the precedent to challenge segregationist laws across the United States. Congress, for its part, as we've mentioned, later passed the Civil Rights Act of 64 and Voting Rights Act of 65, as well as Title IX to protect discrimination based on sex. Of course, let's not forget that the president does have a role in this process. They will have to sign these bills in order for them to become law. And we saw President Truman integrate the Army in the 1950s with an executive order. Presidents can also use their bully pulpit and put pressure on Congress to pass civil rights legislation. As here we see President Johnson asking a joint session of Congress to pass the Civil Rights Act in November of 1963, just 5 days after the assassination of John F. Kennedy, who had been the driving force behind this bill. Presidents are also responsible for enforcing laws and SCOTUS decisions on civil rights. Now, how enthusiastically they enforce those decisions and laws has been a topic in previous lessons, but we see an example of this regarding civil rights when President Eisenhower sent in federal troops to Little Rock, Arkansas, to ensure the safety of those students, integrating a local high school as established by Brown versus Board of Education. And finally, let's not forget the states, as they have played a role in responding to social movements by helping Congress pass the 19th Amendment, giving women the right to vote, and the 24th Amendment, which abolished poll taxes. And speaking of the states, let's leave off on this note. As most of the battles for social movements and civil rights will still pit the federal government against state governments in many cases, again bringing us back to our federal system of government, or federalism. And we have seen and will continue to see how governments respond either at the federal level or state level, and our nation's continued quest for equality and social rights. And that's where we'll leave off with this lesson. I want to thank you guys for watching. Be sure to subscribe. We will be finishing up AP Government. Teachers, just a reminder that this PowerPoint with a wide variety of resources are available at Teachers Pay Teachers. You can just click the link below this video or go to Mr. Raymond's Social Studies Academy at Teachers Pay Teachers.